There's a rumor that ICE is going to be implementing a new trick to detain people and deport them rapidly when that person is actively in removal proceedings. So generally speaking, when somebody asks me whether they are likely to get detained, and I find out that they have an active immigration court case and they have like a future hearing date scheduled, and they have no criminal history or any other reason why the government would think that they will be a danger to the community, my response to them is, you're not going to get detained. You have a future court date scheduled. You have a right to live in the US until the judge makes a decision on your case. So just keep showing up to court and don't get a deportation order and you won't be detained. Now, first of all, let me start with the caveat that that's not always true. You can still be detained when you're in removal proceedings, but the probability of being detained while you're in removal proceedings is low, unless you have some sort of criminal history or some sort of other adverse factor. The government doesn't have the resources to detain every immigrant who's in removal proceedings. Actually, you might be hearing about it right now in the news. There are all these people who are being released on ankle monitors and other safeguards referred to as alternatives to detention because the government has very limited detention facility space. And my understanding is that they are already at full capacity right now. I'm a member of the immigration attorney community, and in our community, there have been rumors of this new trick that ICE is going to use to detain people who are in removal proceedings. And it goes something like this. So imagine you're fleeing for your life, you had to leave your home country, come to the US, and now you're applying for asylum. And I'm your attorney, and we show up to immigration court. And in immigration court, we're just there for a preliminary hearing, and the judge wants to know when we want to schedule the final trial date to make a final decision on your asylum claim. And we schedule it for 1 year out into the future. So we have a year to gather all the evidence for your case, gather all the witnesses, get everything together, and so that the judge can make a final decision on your asylum claim. And ordinarily, under these circumstances, you would generally be protected until your final trial date. You're not going to just be deported while you have a valid asylum claim pending in the United States. Now, let's say you are in that hearing with your attorney, and the adversary in your case, which is the Department of Homeland Security attorney, who's basically trying to get a deportation order. Their job is to get a deportation order. Your job is to be granted relief from deportation or permanent residence or some other relief where you don't get a deportation order. Let's say the government attorney in this case says to the judge, "Judge, I want to make a request to dismiss the charges of removability." It's called a motion to dismiss. And let's say the judge, over my objection, says, "I grant that motion to dismiss." In that moment, you are no longer protected from being removed. And let's say 1 second later, 2 ICE enforcement and removal officers walk into the courthouse, arrest you, and begin your expedited removal from the United States. Expedited removal is a way in which immigration officers can deport you even though an immigration judge hasn't ordered you removed. It's usually restricted to people who've been in the US for fewer than 2 years. So if you've been in the US for longer than 2 years, the argument that the government can use expedited removal to remove you from the US quickly is weaker. But I wouldn't be surprised if the Trump administration tries to make some new arguments to expand that authority in the near future. This scenario that I described to you is a new trick that ICE ERO might be using, colluding with the deportation officers to remove people who show up to their removal proceedings. I've heard that this might start as a pilot program in New York City, and all the attorneys in the area are freaking out about this because this would be a great miscarriage of justice if this actually went into effect. The implementation of a program like this would have a massive chilling effect, discouraging immigrants from actually showing up to immigration court. And if they don't show up to immigration court, they automatically get a deportation order. So whether the matter gets dismissed or they don't show up and they get a deportation order, the Trump administration still gets what they want, another deportable immigrant. So this has understandably caused a lot of immigration advocates to become very upset and ready to take action if this policy actually goes into effect. All right, guys, that brings us to the end of today's video. If you're interested in finding out the most recent policy changes in the Trump administration relating to immigration, be sure to subscribe to my channel. I also do a lot of videos on family-based immigration, naturalization, and deportation defense, because these are topics that I focus on as an immigration attorney. If you need any assistance with any immigration matter, be sure to schedule a consultation. You can find my information in the video description below, and I'll see you guys next time for another video.